All right, we are live again with Doug Rohan of Rohan Law. And I'll tell you, before we even get into this, if you didn't watch our first video, kind of laying the groundwork for some of the framework and some of the details on a couple of suits that the ACC and Florida State have with each other right now, you should go check that out. I'll actually link it right now. You can click the button above. If you've already watched that, then stay tuned and we'll answer some more questions. But Doug, how you doing, man? Thank you for coming on again.
I'm doing great. Thanks for having me. It's been exciting to watch how all this has been unfolding. And I know there have been some follow up questions. And so I've spent some time digging back into some of those additional details as well. And we want to again come back and use my knowledge of the law to kind of explain in more simple terms what are some of these technical issues that are happening.
Yeah. So in our last video, we talked a lot about some of the terms, some of the things that Florida State was alleging, some of the things the ACC was alleging, and we kind of talked about, what both suits kind of look like. And the biggest question we got back, and the biggest thing that I think all Florida State fans and really just people, kind of enjoying this case from outside the fence at times, is what happens next? Like, where do we go from here? And so, again, if you didn't watch the first video, it would help if you pause this and go watch it. But assuming you've seen that, where do we go from here, Doug?
Well, and that's what a lot of people were asking is why hasn't anything happened? Well, first off, we live in a 24-hour news cycle and Twitter where everything's instantaneous, and apologize, but the suit is not going to work that way. There is a process. Now, let me be transparent and show that the ACC filed their lawsuit as soon as they learned about the Board of Trustees hearing. And the reality is that that's something that they had likely prepared weeks, if not months, in advance. So it wasn't like they heard about the Board of Trustees meeting, ran off to a conference room, and hacked out a complaint in 30 minutes. These documents take quite some time to prepare. Similarly, the FSU complaint wasn't drafted after the Board of Trustees meeting. I'm sure they had most of the material already in there, included, and they just added a few additional details from the Board of Trustees meeting. So now comes the time for either an answer for both complaints or more likely a motion to dismiss, because both parties are trying to say they want the home cooking. So they have been working this whole time. They have been preparing these motions to dismiss. And I would expect we're closer to those filings being made available than we are to the complaints and their original filing date. So I would expect in the next few days, weeks at the most, that we would see these competing motions to dismiss to try to get the other court to say these aren't viable in North Carolina or Florida.
And like you said, you would expect both of those to be rejected. You wouldn't think either one is necessarily going to get dismissed.
Oh, perhaps I'm being a homer here, but I personally think the Florida suit is stronger. It's very interesting that the contracts, when they involve diverse parties, usually have what's called a choice of law provision, might even talk about jurisdiction and venue. And these ACC contracts were really written quite poorly because they left those details out, at least based on what's been made available. Now, there were some exhibits that were under seal, so maybe there's some additional information that wasn't provided, but at least based on the public information that was put out, nothing indicated where this contract would be litigated if it was litigated. So that was short-sighted on the part of the parties preparing the contract. That being said, I think that between Florida State being an institution of the state of Florida, all of the issues in dispute and transactions occurring in Florida, emails going back and forth between North Carolina and Florida, I think that ultimately the diversity of the jurisdiction issue is going to be settled on Florida being the proper party. Now, what we don't know is whether that will be the state courts deciding that or whether it will be the federal courts. There has been some discussion about whether or not this will end up in federal court. Both defendants have the right to petition the other court to elevate this to the federal level. So FSU can say, we want this dismissed. If it's not dismissed, we want this complaint to go up to the North Carolina federal court. And the ACC can tell the Florida court, we want this dismissed, but if it's not dismissed, we want this to go up to the Florida federal court. Then you have the two federal courts competing, but you have much more formal procedures there on how those determinations are made. And I would, if I had to guess, I would say both federal courts are likely going to agree that this needs to be a Florida case being heard on Florida laws in a Florida courtroom.
And a little less home cooking probably in federal court than your local stuff.
I think that's right. The federal courts are very insulated from the local politics, the local judges, local prosecutors, and movements. So you have a more impartial opinion as to the law and how it applies to these cases.
So maybe more fair, but would rather play at Doak Campbell than go on a neutral field any time.
Of
So,
course. Of course.
so the complaint happens. There's a time frame in which the complainant has to. I'm sorry, the person receiving the complaint has to respond. Let's talk about that a little bit.
Yeah, I've seen a couple different conflicting issues, and I'm sure some of your followers might be able to have some input to this as well. But it's either 20 days or 120 days, depending on which statute we're reading. But that is told based on any motion to dismiss. So if there is a pending motion to dismiss, the answer doesn't need to be filed yet. The reason why that's important is because discovery isn't going to start until after the answers are filed. So one of the things we all want to see, we want to see the fireworks of the discovery, the depositions, find out some more details. That only happens after the answer. So we have a couple of steps before we get there. And of course, the reality is that this all could be short-circuited if parties were to reach an agreement.
Are they, you see this all the time in litigating and stuff, and I won't ask you to speculate so much as to what they're doing, but I mean, are they talking? Are they playing nice right now? Do you think? Like, do you think they're working on trying to? Have they had settlement conversations? If you had to guess, like, has that come up, or are both sides too mad for that to even happen right now, or like, where do you feel like that probably falls?
I think that's the job of the trial teams on both sides to kind of take the emotion out of this. I think that both parties, the Board of Trustees and the ACC, of course, they're fully convinced that they're right and that they're going to win. And it's the job of the attorneys to step in and advise them and say, look, this is the reality of the situation. And I have no question that there is some urgency to try to provide a solution sooner rather than later. And there's a couple reasons why. First of which is the ESPN deal. ESPN has until February of 2025 to decide if they want to exercise this unilateral option. Well, ESPN wants to know what their inventory is going to be. So they don't want this dragging out a year, 2 years, 3 years in litigation before they have the right to make that exercise. The other issue is that the college football and the scheduling. People want to know where they're going to be playing their games. Travel plans need to be accounted for. And that's something that even if it were to resolve in FSU's favor fairly quickly, we're in the conference for at least 2024, if not most likely for 2025 as well. The last thing is that at the end of the day, the ACC wants to try to keep this information as tight-lipped as possible. The sooner they can resolve this with an agreement, then the better chance they stand of keeping this agreement private. Now, that's a very interesting sub-issue that I'm curious to see how it plays out because Florida State, being a state entity, is subject to the sunshine laws. And so I think there's going to be a competing interest between the statutes that require disclosure of contracts involving the state with the ACC's desire for an NDA or some kind of way to keep this from being filtered out to the other conference partners so that they don't know exactly what the deal was for FSU.
Yeah, it seems like it'd be pretty hard to keep it, with the sunshine laws. If it was tried, in a Florida court and, with Florida laws, it feels like it'd be pretty hard for just the ACC's desire for that to outweigh the law. Especially when, Doug, I've seen people say like there's trade secrets that they've got to like keep, and that's why they keep stuff under lock and key. Like the contract doesn't say like, hey, we show you this many games and you pay us this much money, like every other contract ever. But yeah, their desire to keep it from public light seems like it wouldn't trump the sunshine laws of getting it out in the open.
Yeah, the ACC has really two conflicting interests in that specific issue for you, because as you mentioned when we were talking earlier, the longer this drags out, the longer FSU is in the ACC, the longer they get the revenue from a powerful brand. So on the one hand, the ACC wants this to take a long time, but at the same time, the longer this is a public discussion, the longer this is out for news events and discovery to occur, the less authority and the less power they're going to have as all of their secrets are being revealed.
Overall timing for this, like how long, theoretically could all of this take? How long till they actually get to court? And obviously the settlement could happen at any time, but you know, how long could we be looking at for this to get to court? And then maybe even a follow up to that is how long of a court case would this be? Like, this isn't the OJ Simpson 6 month thing. Like, is it right? Like, this would
Right.
be much shorter once it gets to court, or what are your thoughts on all of that?
Well, we have a very famous case going on right now here in Atlanta, Georgia, with YSL trials, a gang RICO trial, and it took them 7 or 8 months just to pick a jury in that
Oh,
case. So the litigation can be an onerous process. It can drag out. But what's going to happen is after the answers are filed, if a quick settlement isn't reached, and there is a discovery period, the judge is going to issue a scheduling order. And that order is going to dictate what the timelines are for the exchange of documents, for depositions, for the close of discovery, for motions to be filed, and ultimately when the trial would be heard. Now, that scheduling order is subject to change. It's also initially going to be a question of what type of scheduling order the judge is going to assign. There's in Florida 3 different categories of litigation. There's complex litigation, which means the judge needs to sit down with the parties and come up with a custom scheduling order. But the judge could also determine that this is either a general or streamlined case. If this is a general case, and we've got the notes here, discovery is typically completed within about 400 days of the complaint being filed, and a trial typically occurring about 540 days after the complaint being filed. So more than a year. In a streamlined case, that's when they want to try and move things along a little faster. Discovery typically closes within about 270 days, with a trial ideally being heard right around that 360th day after the complaint is filed.
so Christmas 2024 is our best, is maybe our best case scenario. And then the trial itself, obviously, going to be a little bit different. Like, wouldn't necessarily be like a criminal case, but is that with the trial itself? I mean, how long? I mean, I guess that's maybe a crazy question because it could vary so much. But would you expect that it's a super long trial or kind of
Well,
moderate to shorter?
let me start by revealing the realities of our judicial system, and that's about 2% of cases go to trial. The likelihood of this actually ever seeing a courtroom, being in front of a jury or a bench trial is slim to none. Nobody, neither party wants this to be dragged out to that eventual reality. The truth is that this is the type of case that law schools are going to be studying for years to come because it's such a unique and uncharacteristic style of litigation. So the most likely scenario is that there is an agreement, there is a settlement. I personally think that something is likely to be resolved probably as early as the summer. I think it's better than 50% chance that this case gets settled before we kick off in Ireland. But even if it's not, at some point in October, maybe right after the bowl game, that's not unreasonable either. It all is going to depend on how aggressive Florida State is being, on how much they want to spend, and how aggressive the ACC is in not wanting the discovery process to take place.
Yeah. Maybe just after Ireland would be good for settlement because I need to make it back from over there in one piece, and I think we may ingest a little too much Guinness if we're out of there by then. So, okay, let's talk about this pretty quickly, and then we'll maybe wrap up here. But Attorney General Ashley Moody made a little bit of news today. Talk about what was said, what the angle kind of is there, where things are going with the state. Is there, is that something that's going to help Florida State through this, or what are your thoughts around Attorney General Moody's comments today?
So the complaint that the ACC filed in North Carolina had a number of exhibits, and you'll notice if you look through those exhibits, a number of them were filed under seal. What that means is that we have exhibits, we've filed them with the clerk, the judge is able to review them, but as of right now, we think that our privacy interest outweighs the public's interest in seeing some of these exhibits. So by being filed under seal, only the judge at this point gets to see what those exhibits are. The other parties can see what they are, but they're not public records for people to go on and search on the internet and see. The Attorney General is saying effectively, look, you guys are being too secretive. We have an interest as the state of Florida in investigating the antitrust angle here. It's a very creative angle, and I think that there is some teeth and some merit to the action of investigating this as an antitrust suit, but there's no formal method by which the ACC is obligated to respond until a judge forces them to. So again, litigation is going to take time. It's going to drag out. I'm really viewing the Ashley Moody angle as being largely political, largely for show more than for actual effect. Now, there are some teeth. This is a government agent acting on behalf of her constitutional authority to investigate this claim. But I really think that at the end of the day, the litigation and the declaratory judgment actions are going to be handled prior to any true antitrust disclosures and investigations taking place.
Um, because they because Florida State is Florida State can see the complaint or the complaint. Since they are a state entity, can the attorney general not see the complaint unredacted?
She's not a party to the suit at the moment, so until the judge releases it, nobody else is going to see it apart from the parties.
And yeah, that makes sense. So I didn't know if there was like you belong, you kind of belong to the state, so we can kind of see it. We're your parents, so we can see it as well.
That's going to be up to the discretion of the judge, and in this case, the North Carolina judge, not the Florida judge, because those were filed in the North Carolina lawsuit.
Yeah. Has there been anything else that you've reviewed or just since our last video or thought of or changed your mind on, or just anything that you want to bring up? If not, no sweat. I don't want to put a ton of pressure on you, but just anything that we missed or didn't cover in the last video, or just whatever that maybe we can clear up, and then we'll wrap this up.
No, in fact, we've gotten a lot of really positive feedback from a lot of people. That's the nerve-wracking thing. Anytime you come in a public forum and start expressing a professional opinion, of course, some people might have different opinions. And look, we're kind of like coaches in a football game. We might have different strategies or different ideas, but as of right now, I don't think anything that has been said so far and on your shows has been anything outside of what is generally agreeable. And like I said, I do defer if there is another person that has specific experience in this type of declaratory judgment action in the Second District Court of Florida, where Tallahassee is located. Obviously, I would defer to them. But the purpose here is just for us to make sure that there is a knowledge base for everybody to be evaluating this, that everybody understands what the terms mean. And I know everybody loves to have an opinion, and those opinions are your opinions, and largely can play a role in having a dialogue and discussion. But really, I think what's fascinating here has been some of the revelations that have come out regarding ESPN, this unilateral agreement. We talked about that before. And of course, the other conversation about landing spot. Anybody that's saying that FSU is toast and doesn't have a landing spot and is going to get hung out to dry is just being naive. There's no way that FSU has taken this step without first confirming they've got the money available, and second, to make sure that there is going to be a second option for them down the road. I think the fact that we had the Orange Bowl showing that we had the highest ratings outside the playoffs demonstrates the strength of the FSU program. Now, granted, a lot of people were hate watching that. A lot of our enemies were gleefully enjoying our Irish scrimmage, but at the end of the day, it still matters how many eyeballs are on the program, and that's what sells down the road.
I really wouldn't want it to take 500 plus days to get there, but I will tell you, for as many people, you talk about eyeballs, as many people tuned into the board of trustees meeting, if they allowed cameras in the courtroom, I think we'd probably break the internet if it did ever make it the case. So let's talk about this and let's get out. Doug, we let you mention this last time, but tell a little bit about Rohan Law, how maybe people can contact you if needed, what you practice and where you are, and we'll get out of here.
Rohan Law is a law firm based out of Atlanta. Atlanta is the largest booster membership area outside the state of Florida, so we love interacting with our noles, and that's kind of why we enjoy this platform and in talking to everybody on Twitter. You can follow us on Rohan Law Twitter. I'm an active Twitter poster, and we love interacting with people. At the end of the day, I hope you never need my services. We handle criminal defense, DUI, personal injury, workers' compensation, so I know that it's a bad day if you need us. Our slogan is, we want to be your best friends on your worst day. So for right now, all we want to do is is be your friends on Twitter. Follow us on social media, any platform that you choose. And then that way, 2 years from now, 3 years from now, if something does happen to you or a family member, you won't have to try to remember who's that guy TJ was talking about on his show. You'll already know us from Twitter. You already know us from social media, and we'll be right there. We always put out information about how to live your life better, how to respect the laws, how to try to get out of certain problems. So we want to make sure that you know that you have a friend that you can call and reach out to us, especially a Nole that wants to make sure that you get out of whatever dark and difficult situation you're in.
Awesome. Well, Doug, I appreciate it. I'm sure this won't be the last time that we see you on here. So hopefully in a few more weeks, we'll have some motions to dismiss. Hopefully it's 20 days, not 120. But I appreciate you a ton for coming on, and we'll talk to you soon. Go Noles.
Sounds good, TJ. Take care. Go Noles.